Hello, this is Matthew Lemon. How are you, Josh?
I'm good. How are you today?
Doing very well, thank you.
Good. We got court Tuesday. Looks like 9:30. You're able to be with me at that time?
I'm able to do what now?
You're able to be in court with me at that time?
Well, yeah, that could probably work out. The first order of business with this particular case is that we're now going to be filing a motion to disqualify the judge on the basis of bias.
Explain to me what makes you think that would be a good motion for us.
Yeah, I've got the CD of the first time I went in there. I've got the audio of it. And I've not yet requested the CD audio of the second time I went in there. And so what we would need to do is we would need to get you guys to be able to review that audio and to be able to...
What in the audio is there specifically that makes you think that we can file that motion?
Yeah, numerous things.
Explain some of them to me.
Yeah, I'll have to send them to you by email, I guess.
Well, can you just kind of tell me a few of them off the top of your head and we can talk about them a little bit?
How much time do you have right now, Josh?
Not a lot right now. That's
Okay.
why I'm just asking for a couple of them, hoping we can talk through them.
We'll have to find a time when you're available to talk through them, or I'll have to email them to you. What's your email address, Josh?
Josh at LarsenNash.com. Can you tell me the most egregious one that there is, and we can talk about that one?
Sure. That's a great way to start. So, the deputy who was off to the left interrupted the proceedings on the first visit that I had there, and harassed me and physically menaced me. And it appeared to be based on a sort of a wink and nod communication system with the judge. And at the end of that hearing, the judge asked if I would like to try to get counsel appointed. And I said, I would like to leave. Am I free to leave? I would like to leave. And the judge said, and this was Justice Bean, Joseph Bean. Justice Bean said, well, you need to wait for them to give you the piece of paper to give you the information for your next appearance. So I waited to receive that piece of paper. Justice Bean said something to me. I said something back while I was receiving the paper. And after I had just asked for permission to leave the courtroom, and the justice had made me stay to receive this pink piece of paper, then this deputy chased me out of the courtroom and physically menaced me and physically encroached on my personal space. And I have an invisible condition, and this exacerbates my feelings of anxiety. And at my second hearing, I attempted to bring this up to inform the court about this and to put it on record as best as I could, that this was an issue for me, and to request for the court to not allow the deputies to harass me, specifically to ask the deputies not to harass me. And Judge Bean interrupted me, and he did this at both hearings. When I would try to communicate, he would interrupt me and then pause and expect me to know that it's my turn to speak, but then all of a sudden the deputy would jump in and tell me it's not my turn to speak. That's what the kind of thing that happened in the first hearing. And in the second hearing, Justice Bean interrupted me multiple times without allowing me to communicate in a reasonable manner. And most importantly, when I specifically tried to describe to Justice Bean that I have an invisible condition, and that, I'm requesting for the deputies not to harass me, he shut me down as quick as he could. Almost as like he wanted to keep it off the record, is the way it felt like to me. And there's more, there's more. That's the kind of the most outstanding feature. Oh, here's the other part of it. Is that I've actually tried to do my best with my due diligence, and I've been reviewing all the Utah court rules, all the different Utah court rules documents, rules of evidence, rules of criminal procedure, rules of civil procedure, Supreme Court rules of professional practice, and so forth. And it turns out that harassment from the deputies is not just some random thing that occurred to me, but it's actually something which is explicitly defined and outlined in the court rules as something and in the court rules, there's all kinds of things that are either shall or should or must or may or might. And this is one that's it's explicit. It's not a maybe. This is a definitely. That the deputies are not allowed to harass the defendant, and the judges are not allowed to permit the deputies to harass the defendant. That's just explicit. And with the audio that I have of the first one, that'll be very compelling. And if we have the audio of the second one, that'd be even better.
Yeah, so our judge for this Tuesday is Judge Russell. We don't have Judge Bean, so we should be all right.
Okay, would it be a pretrial conference then?
Yep, on one of them it's a pretrial. So you have two cases. The older case, they've filed an order to show cause, which means they're claiming you're in violation of your probation.
Yeah.
And what they're saying on that one is
violation of my plea of abeyance.
Let me finish what I'm
All
saying.
right.
So that the claim there is that you're in violation of that probation by having picked up the new offense.
Plea of abeyance.
Depending on what happens with the new offense, it may or may not be a violation of the old.
It's not probation. It's not probation. There's no probation. It's plea of abeyance.
So plea of abeyance is a period of probation.
Okay.
So it is probation. It may not be supervised in the sense that you don't necessarily have to check in with anyone, but it still is a grant of probation.
Okay.
During that period of a plea of abeyance.
Okay.
So then the new offense, they're charging you with trespass, failure to keep controlled substance in original container, and disorderly conduct. You're aware of those charges against you?
I'm catching up on my notes. Trespass, failure to keep something, and then what was the third one you said?
Disorderly conduct.
Okay, there we go. Yes, I'm aware of all those.
Okay.
And I'll tell you also on the failure to keep, etc., failure to keep C/S. The original ticket was written wrong. It had the wrong statute on there. And I spent a month trying to figure out what that was even about. And I've tried to communicate with the prosecution about that, and I haven't gotten any really meaningful communication from them about that.
So it happens quite often that the officer will put a wrong statute or a wrong code on there.
Okay. Well, if the officer does that, that's one thing. But for the prosecution to put the wrong code in there, that's the problem.
Sure, but it isn't a real big problem, and the reason it is not is that once they file the case, they can amend it at any time. So if they happen to make a mistake and file it under a wrong statute, which happens, I've seen it happen a bunch of times, then they simply file a new information which cleans it up and corrects it.
Okay, well, so we'll need it first. So what I would say is that we're not ready for pretrial on the 19th. What we would first need to do is get a motion relating to that. And
we don't need a motion for that, and we are ready for pretrial. Pretrial is just a first chance where we have to sit and chat, talk through the case, talk about what's being offered, and see if we can come to some sort of resolution or agreement. If we can't, then at that point we can schedule further proceedings, such as a trial, or if we need another pretrial, the judge will grant that to us. But we don't need any motions related to how the initial citation was filed. Right now, they filed an information that outlines those 3 charges, and we can work from that information and start there and see if we can work something out.
So you're saying you have an information that has the correct number for the failure to keep C/S whatever? It has the correct statute number?
The correct statute number, you're saying?
Yeah.
Let me just verify what I got here. Hang on. I'm not even seeing an information filed at all yet. Yeah, it doesn't look like they've filed even an information yet at all.
Okay, so before we'll be able to.
Let me hold on.
Yeah.
So it's not real crucial that an information be filed. If we want it and we demand it, then they'll create it. And they will. It just takes them time. They have up to 2 years to file that initial information.
Okay.
And so we've got plenty of time to do it, and it doesn't help us that it's not in there. It doesn't hurt us.
It hurts. It hurts me. It hurts me.
Explain to me how it's hurting you.
Okay, so this is my first time speaking to counsel, and it's May 14th. Okay, and counsel is ready to go to pretrial. Let's go.
Yep.
And counsel doesn't know any of the facts of the case at all.
I've got the file, and I've got a statement of facts before me.
A statement of facts from whom?
From my staff, who has outlined a brief factual basis of what occurred.
Okay, so.
So Matt,
Yeah,
let me
nothing.
explain this too. So generally, a pretrial conference is the first chance that we have to meet a client. And oftentimes, and I say often, nearly all the time, we arrive at that first hearing with our clients, and that's all we've got before us is a copy of the report and kind of a brief factual outline of what occurred.
Okay.
And so a pretrial would go like this. I would sit and I'd say, Matt, good to meet you. My name's Josh. What I see here is these charges. Here's kind of a brief outline of what they're claiming occurred. Matt, did that happen? And so then I would talk back and forth with my client about, kind of his side of the story. And the discussion would go something like this. Hey, I see that they're offering the following. Is that something that interests you? If not, is there some sort of negotiation we can do with the prosecution? Or is it a case that you want to fight? Is it time to just set it for a trial? And we would have all of those discussions about how to proceed. And then, Matt, you would get to make the decision as to what the next step would be.
Okay. So,
That's how we do these cases. That's what a pretrial conference is.
Okay. So I'll go ahead and skip through all of that. I can tell you that I do not accept the plea bargain. I do not accept the plea bargain. There's no negotiation. The only offer that I'm willing to accept is a letter of apology and all charges dropped. That's the only negotiation that's going to come out of me. So we already skipped through all that. So I'm glad we took care of that. That was easy. Okay, let's go on to the next thing.
Great. Now the next step, Matt, let me jump in a little bit here and just tell you the next step is there's two ways we can do it. You have a right to a trial, right? We do not agree with what they're saying occurred here. We dispute it. We aren't going to accept an offer. And so it's time to start thinking about trial. You have a right to either a bench trial or a jury trial. Do you know the difference between the two of those, Matt?
Yes.
Okay. You get to choose. And I'll tell you, Layton, they're pretty backed up as far as trial settings. If we set a bench trial, we probably would get a date in September or October, maybe a little sooner. I don't know for certain how quick they are setting bench trials. Jury trials would probably be September or October is just my guess. And so I recommend we get this thing set for trial. And then in the meantime, we can have further discussions to discuss with you and prepare a defense and prepare for trial.
Yeah, I don't know that I'll be ready by September or October. And so first what I need to do is have probably at least 2 pretrial hearings before we're ready to really set the trial date. And then we can, keep working on discovery at that point.
What is the specific reason why you think we wouldn't be able to be ready by September?
Because I have not reviewed any of the information with counsel yet, and so the counsel has no familiarity with the case whatsoever.
It would take us 5 months to do that.
I've already spent 5 months working on discovery. I've got just loads and loads and loads of body camera footage and all kinds of grammar requests I've done and documents and police reports. So I'm really doing a lot of footwork here to help out. I'm not just, hoping that some random stuff is going to happen. And so I know the scope of the information that I've looked at so far, and I'm still trying to get my hands around it, and I was there. And this has been my full-time focus. Now, I'm not an experienced attorney, but I am an experienced communicator, and I'm an experienced corporate trainer. And so I have enough knowledge about this situation right now at this time to know that I'm not ready to set a date for trial until I have a lot more clarity on what's coming up. So, basically at pretrial, we still got to figure out whether or not this venue is going to work out at all, because I've been severely harassed at that venue. And it is a little bit better to know that Judge Russell will be there on May the 19th and not Judge Bean. But that does not resolve the long-term issues of the deputies having harassed me at that location. And I do not feel safe at that location. And so, what we need to work toward is getting information, good, proper information about the way that Judge Bean treated me and the way that the deputies treated me the last 2 times that I went in there. And start working on, first of all, dealing with these issues of order and decorum, and ensure that these issues of order and decorum are properly addressed at various pretrial hearings. Once we've addressed these matters of order and decorum, then we'll be ready to start looking at setting a trial date. I have not done any depositions yet. I have not...
You don't do depositions on criminal cases like these. We won't be doing any depositions.
Well, I will. And I will also be subpoenaing a lot of information. And I haven't been able to send out any subpoenas yet, and I'll need your guys' assistance sending out the subpoenas.
Well, depending on what you're looking for, we're not going to engage in a fishing expedition.
A fishing expedition? You don't even know anything about the case, and you're saying that to get basic information would be a fishing expedition?
Again, I didn't say I knew.
Did you ever previously...
I tell you that I'm not going to engage in a fishing expedition.
You said you don't want to engage in a fishing expedition.
I'm not suggesting that what you're asking fishing expedition because I don't know what that is.
You're inferring it.
Well, I'm telling you, I'm not going to.
Yeah, because, well, you don't know anything about it. So you don't know anything about it. You don't know anything about it.
Then we're not going to request them.
Okay, did you ever work in law enforcement before, Josh?
I did not.
Do you have family in law enforcement?
I do not.
Okay.
But I've been doing this for 20 plus years. I got a pretty good idea of how the system works and what motions are appropriate and what additional information can be appropriate.
Yeah, and I'll tell you.
I'm not saying, Matthew, I'll try not to interrupt you and you try not to interrupt me, but
Right now, Mr. Larsen, right now, Josh, I need you to listen to me. It is time for you to listen to me, Josh.
Matt, no, that's not how this is going to work, Matt. I've been very respectful of you. I've tried not to talk over you. And I would ask that you do the same for me.
Not right now. We're about to finish this call. And you're working for me. I'm not working for you. And I know what dismissiveness sounds like. And I know what it means to be treated like I don't matter. And to be treated like I'm not important. And that's what you're doing to me. You're treating me in a very dismissive manner, Josh. And so now this conversation is officially over. Goodbye.